provincial minister vacates office. Clause 15, amendment of Article 149. The clause provides for the amendment of Article 149 of the Constitution by inserting the word electoral before the word boundaries. The clause is supported as the amendment is intended to clarify the scope of the mandate of the Electoral Commission of Zambia with respect to boundary delineation. Further, the mandate of the Commission does not include provincial boundary delimitation. Clause 16, amendment of Article 153. The clause provides for the amendment of Article 153 of the Constitution in Clause 2 by insertion of a new paragraph B so as to include a member of parliament from each constituency within the districts on the composition of the council. Further, Article 153 of the Constitution is amended by the deletion and replacement of Clause 6 so as to clarify the term of the council. It's 5 years, which commences from the date of the first sitting of the council after a general election and ending on the day Parliament is dissolved. Additionally, Clause 153 of the Constitution is being amended to insert a new Clause 7 to prohibit a council from sitting or conducting any business 90 days before the holding of a general election. The Commission does not support this clause to the extent that the proposed Article 153(7) relates to the proposed Article 81(3), where it stipulates that Parliament shall stand dissolved a day preceding the date of the general election. The Commission submits that the Council should be dissolved 90 days before a general election so that vacancies are created in the Council and necessary electoral processes in the electoral cycle, such as nominations and polls, are conducted. The Commission also notes that there may be a need to provide a clear definition of mayor, council chairperson, and ward councillor, as the Constitution currently deems a mayor or council chairperson to be a councillor in terms of composition of a council. Article 153(2) categorizes mayors and council as councillors. Therefore, there is need for a clear distinction of who is a councillor and a mayor and a council chairperson. Clause 17, repeal and replacement of Article 154. The clause provides for a repeal and replacement of Article 154 of the Constitution so as to maintain the position of mayor and council chairperson. Further, the clause provides for the qualification required for a person to be eligible to be elected as mayor or council chairperson. The clause is supported. This creates uniformity as the qualifications for the mayor and council chairperson, I beg your pardon, chairperson, should be council chairperson, are contained in subsidiary legislation, while those for other elected office bearers are contained in the Constitution of Zambia. Clause 18, repeal and replacement of Article 158. The clause provides for the repeal and replacement of Article 158 of the Constitution in order to introduce a new mechanism for filling vacancies in the offices of mayor, council chairperson, or councillor. Under the proposed amendment, where a vacancy arises in any of these offices, the political party that sponsored the member who previously held the seat shall be required to elect another person to fill the vacancy. The replacement shall be made within 7 days from the date the vacancy occurs. The Commission does not support the proposal to amend Article 158(1) and its subsequent clauses to the extent that the current process of filling a vacancy in the office of mayor, council chairperson, and councillor should be maintained. The rationale for not supporting this proposal is that the mayor, council chairperson, and councillor are elected directly by the public, the electorate, through the first past the post electoral system. Eliminating by-elections for this category of representatives would deprive the electorate of their democratic right to choose a replacement of their preference when a vacancy occurs. Furthermore, the fragmentation of political parties does not support a system in which parties are allowed to fill a vacancy for the office of mayor, council chairperson, and councillor without a by-election. Allowing political parties to directly replace such offices could undermine democratic accountability. The Commission is of the considered view that the electoral system for filling in the vacancy for mayor, council chairperson, and councillor be maintained so that the populace in that district or ward, I beg your pardon there, Chair, again, are given the an opportunity to choose their representative. Clause 5 prohibits the replacement of a vacancy under Clause 1 within 180-day period before a general election. Clause 6 provides for the Electoral Commission of Zambia to set the date and time for the submission of the person to assume the vacant seat in the National Assembly and provide for the period of completion of the process in Clause 1 in a statutory instrument. The Commission is of the view that the current Article 158 be maintained. Clause 19, amendment of Article 159. The clause provides for the amendment of Article 159 of the Constitution by the insertion of the words undetermined immediately after the word heard, so as to clarify that a local government election tribunal is required to hear and determine an election petition of a councillor within 30 days of the filing of the petition. The Commission supports the amendments as it aims to ensure procedural clarity and judicial finality in local government election petitions by emphasizing the court's, in this case the tribunal's, duty not only to hear the matter but also to render a determination within the prescribed time frame. Clause 20, amendment of Article 176. The clause provides for the amendment of Article 176(3) of the Constitution by deleting the words 10 and substituting therefore the word 5 so as to reduce the number of years experience required for the Secretary to Cabinet. The Commission has no comment on this clause as it does not fall within the mandate of the Commission. Clause 21, amendment of Article 178. The clause provides for the amendment of Article 178(1) of the Constitution by deletion of paragraph B so as to ensure that there is no vacancy in the office of Attorney General when a person assumes the office of President. The Commission supports this clause. The Commission is of the view that there is need for continuity in these offices, especially since the law places a duty on the Attorney General's chambers to clear government contracts and to advise government on other related matters. A vacancy in these offices creates uncertainty in the operations of government. Clause 22, amendment of Article 179. The clause provides for the amendment of Article 179(4) of the Constitution by the deletion of paragraph B so as to ensure that there is no vacancy in the office of the Solicitor General when a person assumes the office of President. The Commission supports this clause. The Commission is of the view that there is need for continuity in these offices, especially since the law places a duty on the Attorney General's chambers to clear government contracts and to advise government on other related matters. A vacancy in these offices creates uncertainty in the operations of government. Clause 23, amendment of Article 266. The clause provides for the amendment of Article 266 of the Constitution by the deletion and substitution thereof of the definitions of adult, by-election, child election, general election, and term. Further, the clause provides for the amendment of Article 266 of the Constitution by inserting a new definition of constituency-based seat. The Commission proposes deleting the word independent wherever it appears in the definition of by-election. Further, as indicated earlier, the Commission proposes that the definitions for mayor, council chairperson and councillor should relate to the election they apply to. Chair, I submit.
ECZ, thank you for your submission. Honorable members, that's the submission from the Electoral Commission of Zambia. We are now free to seek points of clarification on their submission. Honorable Nkombo.
Thank you, Chairman. I see that the Commission, good morning and welcome, supports the clause for delimitation of constituencies. I would like to find out, Chair, at what stage the Commission is going to communicate to the nation which constituencies will be due for delimitation.
Thank you, Honorable Nkombo. Witness, please take note and you attend to that subsequently. Honorable Mungandu.
Thank you, Chair. I'll take the witness to clause 9. Amendment of Article 72, where you are proposing that the clause provide for the amendment of Article 72(2) H of the Constitution by deleting the existing provision and substituting it with a new clause 2H. The purpose of this amendment to expand the circumstances under which a seat of a member of parliament becomes vacant. You've qualified in the subsequent sentence specifically the revised clause that a parliamentary seat shall fall vacant not only in the previously stated instances but also when a member of parliament is disqualified under any provision of the Constitution. What I want to find out here, what is it that this is going to cure? Which part of the law has been problematic where a member is disqualified under the Constitution and they've continued to be a member of parliament? The instances. I know the most important question has already been asked by Honorable Nkombo. Zambians want to know when is the delimitation report going to be made public so that they know which constituencies are being delimitated. I submit.
Thank you, Honorable Honorable Mwamba.
Thank you, Chair. My point of clarification is on clause 2, amendment of Article 47. So my point of clarification would be when it comes to the PR system, is it of your view that there should be a PR ballot, or it should be the presidential vote that should set the threshold for the PR system? I submit, Chair. Thank you.
Thank you, Honorable Mamba. Just for guidance, I think they've indicated in their submission that they do not support the ballot, but they'll add, they'll make their submission on that. Honorable Sabah.
I think, Chair, mine is on the same clause 2, the last paragraph of the submission. In the part list voting system, each part submits a list of candidates. After vote counting, seats allocated to each part in proportion to the votes received. So according to this submission, political parties will submit to ECZ the part list, and then after the counting, then the distribution will be done. Now my question is, how will be the political parties submit lists without knowing their share? Because according to this one, it's like they are going to submit the list before they know their share. Because my understanding is that after the voting count and then you distribute, saying part A, your share is maybe 60%, part B, your share is 30%. Then they will submit maybe 60% of 20 is 16. They will submit 16 names. But in this submission, it's like the names will be submitted before the distribution of share is given to the political parties. So maybe you can clarify on this submission.
Thank you. Is it on the same honorable? Okay, please, President.
Thank you very, very much. Really connected to the questions by the two colleagues, Honorable MP for Kasama and for Chikankata. ECZ, I want to know from you which vote will count in determining the PR seats if by some circumstances no candidate manages to get a straight 50% plus 1, which will determine or require a rerun. Will it be the first run or the second one that will determine the number of seats?
Okay, perhaps the witness may attend to those. The Honorable Kambit, Honorable Daka will come to the second round of questions. Witness, you may proceed.
Thank you, Honorable Chairperson. At this stage, I seek your indulgence to invite my colleagues to respond to some of the clarifications. I'll speak to the first question in terms of where Honorable Nkombo sought clarity from the Commission as to when the Commission will indicate to the people of Zambia which constituencies are earmarked for delimitation. Honorable Chairperson, your committee may wish to note that following the public consultation exercise that the Electoral Commission of Zambia undertook in 2019, a report was prepared and that report was submitted to the executive. It is that report, Honorable Chairperson, that has since been revised and again submitted to the executive to inform the number that is indicated in the bill. Honorable Chairperson, once the Electoral Commission of Zambia submits that report or such a report to the executive, it's no longer in the hands of the Commission to release that report to the public. It is with the executive. So where the Commission stands is now to await for the amendment of the Constitution, and once the implementation, or the actual implementation of the new constituencies is done, indicates so the new boundaries of the constituencies in a statutory instrument, and thereby inform the public of which constituencies have since been established following the amendment to the Constitution. Chair, I submit. I'll invite our Commission Secretary to speak to the questions relating to clauses, the other clause on the disqualification for a Member of Parliament.
Thank you, Chair. On that particular question, I'll ask our Manager Legal to speak to it. Thank you.
Thank you, Chair. Thank you, Chair and members. The current provision in the Constitution speaks to a member a vacancy being caused by a disqualification as a result of a decision of the Constitutional Court. So in terms of practicality, we have I think not seen any decision of the Constitutional Court that may lead to the disqualification of a member. So what is being proposed in the bill is that it gives more clarity what will trigger the vacancy. It is as indicated so as indicated in 9 in clause 9 article 72, that is 2H, the proposal is that the disqualification be when a member of parliament breaches the constitution. I think it gives it sets a parameter for the constitution. It's a constitutional court that will still interpret the breach of the constitution itself. So it then gives a parameter for when the seat can become vacant. I submit, Chair.
Okay, we'll have the follow-ups that there's yes, I know. Let them adequately respond, then we come to the follow-ups so that they don't lose track. Honorable Sabah asked a question on the PR system, so did Honorable Nkombo.
Yes. Thank you, Chair. I will begin, then I'll invite Commission Secretary to speak further on the questions relating to Clause 2. So, in terms of allocation of seats on the proportional representation system, the Commission does not support a separate ballot, but rather to use votes obtained in the existing election system to determine the proportion to be allocated to a particular political party. In the submission, the Commission has taken note that the bill proposes prescription of the particularities of this particular clause in terms of the Electoral Process Act. However, it does indicate by way of example that the presidential could be used to Title 2. Now, in terms of how the party would know their share before submitting the list, I invite Commission Secretary to address it.
Usually in a proportional representation system, the political parties are supposed to submit lists. So they can submit lists of maybe 10 people, so that if there's a vacancy, they'll go to the next person. And again, if there's a vacancy, they'll go to the next person. So in terms of best practices, it's better for the political parties to submit the lists before the election. Then in terms of if there's a rerun consists of 2 candidates, so it wouldn't be practical to use the second ballot. It would be practical to use the first ballot where you have a lot of political parties. Thank you, Chair.
Chair, if I may add on this, with your permission, Chair?
Please proceed.
Okay. On the lists, just to clarify further, that the political parties would be required to submit lists assuming they get 100%. So all of them would submit lists assuming they'll get 100% of those seats. But then the allocation will be based on their performance, as it were. Thank you.
Okay, follow-up questions to the responses, then we can get new questions. Honorable Nyambose, then in that order. Honorable Sabah, then Honorable Banda, and Honorable Daka. Is it new question? Okay, let's have follow-up questions on the same issue.
Thank you very much, Chairperson. This is Michel Kimtetu Nyambose, a member of this committee. My follow-up question was, Chairperson, was on the delimitation. Is on the delimitation, as if I got the the witness correctly, that delimitation would await the act or the constitution to be done first. Once approved, that's when I think ECZ would indicate which constituencies. Is that correct position? The other one is, yes, indeed, there's been an outcry out there. People are walking long distances to cast their votes. Is the delimitation considering taking polling stations, indicating new polling stations that would make people easily cast their votes than the current situation where they're walking long distances? Are you going to delve into the detail of creating more polling stations for the people to vote? Thank you, Chair.
Thank you, Honorable Sabai, the Honorable Kambita, and the Honorable Banda and so forth.
Thank you, Chair. The response from the Commission is that before we go for elections, each political party will assume that they'll have 100% of PR, so they will be allowed to submit maybe the number, for instance, 20 names for the women. And then after the election, you apportion the percentages. But my question is, from that 100% list, who will choose the names from that list? Because, you know, we are living in the world where information for that my name was on that list, and then when the decisions are made who will be picked, my name will not be there. So now, who will be given the mandate from this 100% list to choose the particular names according to the percentages of these individual political parties? I submit.
Honorable Ambita.
Thank you very much, Chairperson, and good morning once again. ECZ. My name is Brian Kambita, Member of Parliament for Zambezi East Constituency, Northwestern Province. I didn't have the chance to introduce myself. Speaking to Clause 2, Amendment of Article 47, you've submitted on page 4 of your submission, I think the 4th and 6th paragraph is what I'll refer to. On the 4th paragraph on page 4, you are suggesting that the method for distributing proportional representation seats should be set out in the Electoral Process Act, which is a subsidiary legislation to the Constitution. And you also don't give a detailed submission, of course, on how that should sit, understandably. But again, we are relying on you as experts to submit to us. On the 6th paragraph, you've again let it open, where you have suggested that an example or one way of achieving this could be to use the presidential vote and set the threshold for the PR system. I would like to hear from you in categorical terms as to what you feel would be the best approach given our current situation, where we have the presidential system of election, and this PR system seems to be bringing in another dimension which is not familiar or synonymous with the presidential system. Could you give a little more clarity as to what you prefer would be the system to use, especially that you are suggesting just an example? What is there any other option?
Okay, thank you, Honorable Kambita, just for guidance. The witness attended to that, but they can attend to it again for your comfort. Honorable Sefo, Honorable Banda, then Honorable Sefo.
Thank you so much, Chair. Let me take this opportunity to introduce myself as Emmanuel Banda, Member of Parliament for Mchinga Constituency, that's in Serenje District. And my point of clarification is on Clause 9, Amendment of Article number 72. The last part, of course, not before the Commission comes to support, says specifically the revised clause provides that the parliamentary seat shall fall vacant not only in the previous stated instances, but also when a member of parliament is disqualified under any provision of the constitution. So now, there has been this fear that since there was that proposal which the commission said they do not support, or rather where a member of parliament is maybe disqualified by a political party that sponsored him. And we have seen previously, until a member goes to court, that's when the court comes in. But in this case, it says that it has to be determined by the constitutional court. So I wanted to understand, because there will be two sets of parliamentarians here. There will be those that will be elected through the provisional vote, and there will be those that will be elected through, a constituency-based election. So which one are you specifically referring to, where the constitutional court comes in? Is it the one like I hold the constituents, then I'm expelled by my political party, the party that supported me, and if I don't go to court myself to go and seek justice that I've been erroneously expelled, does the constitutional court immediately takes over or to my case, or it only applies to those that will be picked by the political parties based on the proportional vote? Chair, thank you.
Thank you. Witness, I hope you're taking note. Honorable Sefulo and Honorable Anakoka.
Thank you so very much, witness. Let me also take the opportunity to introduce myself. My name is Wesoka Sefulo, a member of parliament for Mondi constituency in the Western Province. I wanted to find out, you've spoken about the MMPR system, and also how the proposed numbers will come through political parties. But of particular concern is that we have a lot of youth-based organizations where we can tap into the youths that are not involved in politics, but they're able to contribute to the growth, and also on the ones that are coming through, the disabilities. We have organizations that represent people that have disabilities. I wanted to find out if this is the only way that we can get the youths, the women, and the people that are, the people that have disabilities, to get them only through political parties and neglect the other civil societies that represent women, that represent the youth, and that represent the disabled. I submit. Because not everyone that is involved in politics, it's not every youth that is involved in politics. We have that can contribute that are not politically affiliated. I submit.
Thank you. Honorable Anakoka, we had Honorable Kandafla before you. So let him proceed, and I'm sure most of these are related.
Thank you, Chair. I think it's on the same delimitation, just a write down what Honorable Chasefu asked the Commission. Just for clarification purpose, you said that a report was done and presented to the Executive, of which the informed decision of this number of constituencies which will be delimited came from. And then it's upon this bill going through that it also will be known who actually do the giving out. Is it the Commission or the Executive? Thank you.
Thank you, Honorable Kandafla. Honorable Anakoka, then witness, you can attend to those.
Thank you very much, Chair. Witness, my name is Mwita Anakoka. I'm Member of Parliament for Luena constituency. In relation to the proposed amendments under Article 47, where you are talking about a list submitted before elections are held, have you had regard to the fact that one of the reasons for introducing a PRR system is to improve on inclusivity, and that inclusivity is not only in terms of marginalized people, but it's also in terms of regional representation. So if a party, for example, finds itself strong in one part of the country, but not so strong elsewhere, the only way they can realize how strong or underrepresented they are nationally is after the constituency vote has been cast, which means submitting a list prior to holding elections might result in a situation where the factors that prevailed at the time of compiling that list are not the same as the reality that comes out of the elections. And you want to make sure you have got national representation. Don't you think, with that in mind, it might be necessary for us to rethink the idea of when this list should be submitted? Because only after elections do you now have the opportunity to respond as a party to the reality on the ground, in order to ensure there is national representation. Thank you, Chair.
Thank you. Witness, please attend to those.
Thank you, Honorable Chairperson. Start with the first intervention. May wish to note that whereas in public discourse we refer to the reports prepared by the Commission and submitted to the Executive as delimitation reports, but in strict terms the is only after the actual delimitation has been conducted. So what the Commission prepares are proposals to the Executive, and those proposals inform the amendment of the Constitution. And once the Constitution is amended, then the Commission is mandated now to go on the ground and actually delimit the constituencies and come up with a report which is published via Government Gazette. So that is the sequence of events, Honorable Chairperson. So to repeat myself, it is the Electoral Commission that will conduct the delimitation and will inform the public via a statutory instrument in terms of the new boundaries of constituencies. In terms of delimitation of polling stations, I'll invite Acting Director to speak to it.
Thank you, Chair. Honorable members, a delimitation has got 3 stages. There is delimitation of constituencies, there is delimitation of wards, there is delimitation of polling districts. With regard to delimitation of polling districts, where we are now with the conclusion of voter registration is something that we cannot do between now and the 13th August 2026. With regard to delimitation of constituencies, is something that can be done between now and the 13th of and nomination that can be done. So, to be very clear on the Honorable's question, creation of polling stations now, it cannot be done. We cannot do it after 2026 general election. I hope I'm clear.
I think you're actually opening up to more questions, because you submitted a report before the Executive delimitation report. So that's 12 constituencies, I believe. So you're talking about polling station and wards. So if you've delimited constituencies, it means you've already delimited the polling stations and wards. Could you clarify on that? And when you say that you delimitate after the law is passed, what then have you submitted to the Executive? And perhaps there's another for Honorable yes.
Chair, I'm asking this question just to buttress your point. Especially, I'll give an example of Chasefo. They were asked to submit the names of proposed polling stations. Way back, I remember. And these were submitted, and I presume it's across the country with a view of looking at them. And to get that response, I would further want to agree. Maybe the ECZ is considering that, because this was done way back. So it was my hope that this would be clarified at this point, Chairperson.
Thank you. Please clarify. Honorable Daka, you had an intervention? Okay. Okay.
Honorable members, what I meant is, in 2019, we did delimitation of constituencies, wards, and polling districts. The delimitation of wards, they were effected. The delimitation of polling stations and pollings were effected. What was not effected was constituencies. I think that's what I meant, sir. Thank you.
Thank you for the clarification. Director, Chief Electoral Officer, maybe you want to add?
Yes, Honorable Chairperson, that there was clarification around delimitation of constituencies, whether that would also invariably mean delimitation of polling stations. From an operational point of view, Honorable Chairperson, when we are delimiting constituencies, in simple terms, we will be regrouping the wards into new constituencies.